listening to the Jordan is My Lawyer podcast. This is your host, Jordan, and I give you the legal analysis you've been waiting for. Here's the deal. I don't care about your political views, but I do ask that you listen to the facts, have an open mind, and think for yourselves. Deal? Oh, and one last thing. I'm not actually your lawyer.
Welcome back to the Jordan is My Lawyer podcast. Happy Friday. I have 4 stories for you today. The first is going to be about Donald Trump's lawsuit against Michael Cohen that was just filed this past Wednesday. The second story is going to be about those Mifepristone rulings where, there's conflicting rulings out of Texas and out of Washington, and then it went up to an appellate court and where that issue currently stands. The third story is going to be about the Tennessee representatives that were able to return to the House on an interim basis. And the last story is going to be about the suspect that was arrested in the Pentagon document leak. So we're going to talk about how they ultimately found that suspect and what the apprehension looked like. Before we get into today's stories, let me just quickly remind you guys to leave me a review on whichever platform you listen, whether that's Spotify, Apple Podcasts, Google Podcasts, whatever it is, it helps me more than you know. So without further ado, let's get into today's episode. On Wednesday, Donald Trump filed a lawsuit against his former personal attorney, Michael Cohen. Obviously, Michael Cohen has had his name in the news lately, as has Donald Trump, because of this indictment and everything surrounding it. But this complaint was filed in federal court in Miami, and it accuses Michael Cohen of basically breaching his fiduciary duties that were owed to Trump, not only by virtue of the attorney-client privilege that they had, but also by virtue of the confidentiality agreement that they had when Michael Cohen was hired. It also accuses Michael Cohen of unlawfully converting business property by misrepresenting a business expenditure, which we'll talk about, but that's a much smaller portion of the case. So the complaint says that, quote, defendant committed these breaches through public statements, including the publication of 2 books, a podcast series, and innumerable mainstream media appearances. Defendant appears to have become emboldened and repeatedly continues to make wrongful and false statements about plaintiff through various platforms. The complaint goes on to say that the defendant has reached a proverbial crescendo and has left the plaintiff with no alternative but to seek legal redress. And of course, the plaintiff in this complaint is Donald Trump. The defendant is Michael Cohen. So the first thing that the complaint gets into and discusses a little bit is Michael Cohen's what the complaint calls personal and professional downfall. So it first starts by talking about that 2018 raid that took place at not only Michael Cohen's house, but also his office, his hotel room, his safety deposit box, all that good stuff. And shortly after that, Cohen met with this attorney named Robert Costello. And basically, according to the complaint, Costello is the one that persuaded Cohen to testify against Donald Trump so that he could avoid any jail time for anything he had done wrong, work with the prosecution and get out of jail that way. And Cohen, again, according to the complaint, just kept saying that he didn't have anything on Donald Trump. At one point, he said, quote, "I swear to God, Bob, I don't have anything on Donald Trump." The complaint then talks about how allegedly Michael Cohen told attorney Costello during a meeting that he had decided on his own to see if he could take care of the Stormy Daniels situation, making clear that the payment to Stormy Daniels was completely his idea. He took out a loan to pay Stormy Daniels the $130,000 and was never reimbursed by Donald Trump or the Trump organization. So then it gets into Michael Cohen's fiduciary duties, both as an attorney as well as under that confidentiality agreement. So if you've ever hired an attorney, there's an attorney-client privilege. This is governed by the rules of professional conduct. And as an attorney, when they pass the bar and they take their oath, they have to maintain this attorney-client privilege with their clients. The attorney-client privilege says that your communications with your client are confidential. On top of that, when Cohen was hired as Trump's personal attorney, Cohen signed a confidentiality agreement. So now he had extra duties of confidentiality owed to Donald Trump by way of this agreement. Well, Trump says that Cohen breached these duties, specifically with his 2 books. So he has one book called Disloyal and another book called Revenge. He also has a podcast called Mea Culpa, which launched in September of 2020. And what Trump says is that these books and this podcast and him, making these various accusations in the books and on not only his podcast, but also various other podcasts he has gone on as a guest, breaches these confidentiality agreements and the fiduciary duties. So specifically in regard to the first book, Disloyal, the complaint says that Trump sent Michael Cohen a cease and desist letter in April of 2020, and it put him on notice, essentially, that if he went forward with releasing the book, this would violate his confidentiality duties. Michael Cohen released the book anyway. It was released on September 8th, which coincidentally was less than 2 months before the 2020 presidential election. Trump says this was intentional because that's when it would have been the most lucrative time to release his book, and also when the book would have had the most damaging reputational effect on Trump. So he says that release was very intentional, and not only was he put on notice, but he willfully disregarded that notice. Then more recently in 2022, Michael Cohen released his second book, Revenge. And in that book, he accused Trump of being a liar. He said that Trump would lie, about anything and everything. He called Trump a racist, a bigot. He claimed that Trump didn't care at all about national security. There was just various accusations throughout the book. And then the complaint dives into the podcast. So it talks about how Michael Cohen had hosted Stormy Daniels as a guest 4 different times, and during those appearances, they discussed details of the allegations against Trump. They revealed client confidences about, Michael Cohen's role in the matter and Trump's role in the matter, and things that Trump says should have never been talked about. So in total, there's 4 counts. There's a breach of fiduciary duties, a breach of contract in regard to that confidentiality agreement we talked about, breach of implied covenant of good faith and fair dealing, which is again in regard to the confidentiality agreement. Specifically in that agreement, Michael Cohen had a duty to act in good faith, and instead, Trump says he intentionally and maliciously breached that duty. And then the 4th count is for unjust enrichment, so making money off of these alleged falsehoods told in his books and on podcasts, etc. So what the complaint says as far as damages, and this is a little bit different than what the headlines are saying. So as far as damages, the complaint says that Donald Trump is seeking actual, compensatory, incidental, and punitive damages in an amount to be determined at trial, but expected to substantially exceed $500 million. So he's not asking for $500 million. I mean, if this gets to a trial, yes, he may, his attorney may say $500 million is a reasonable amount, but what it's saying is that he's actually looking for an amount to be determined at trial, but he's expecting it to be more than $500 million. Keep in mind, this amount takes into account the damage that's been done to his reputation over the last few years, the actual amount of money he's lost because of all of this. There's also an amount thrown in to punish Michael Cohen should it be found that he wrongfully committed the acts that he's accused of. And there's incidental damages. I mean, there's a lot of damages thrown in there. So while $500 million is a huge amount of money, obviously, there's a lot more to it than meets the eye. I mean, he was just indicted for things that Michael Cohen said, so there's just a lot more to it. He's also seeking restitution and disgorgement of any profits, payments, compensation, advances, royalties, really any proceeds received by Michael Cohen as a result of his books and his podcasts and things like that, anything that makes him money. And finally, that last amount is that $74,000 that I mentioned in the beginning of this story, where Trump says basically Michael Cohen told him that he was owed X amount of money, when in reality he was owed $74,000 less than that. So he's saying he overpaid or over reimbursed Michael Cohen $74,000 due to Michael Cohen's own misrepresentation, and therefore he wants that $74,000 back. So that is the lawsuit in a nutshell. Let's move on to our second story, which has to do with these conflicting Mifepristone rulings out of Texas, Washington, now the Fifth Circuit Court of Appeals. There's a lot going on. A lot of people are confused as to what these rulings mean. So last Friday in Texas, a U.S. district judge ruled that the FDA's approval of Mifepristone, which is one of the most commonly used abortion medications here in the United States, should be put on hold, meaning that the FDA it's no longer an FDA approved drug, basically. That same day, within 20 minutes, a U.S. district judge in Washington ruled that the FDA can't change the status quo of Mifepristone in states that filed this lawsuit. So it sounds confusing, but I promise by the end of the story, it'll all make sense. So let's first talk a little bit about Mifepristone. What is it? And then we'll talk about the rulings in Texas and Washington. And then we'll talk about the appellate ruling. And then we'll finish by talking about where the Supreme Court is supposed to take this from here, or the emergency relief that was requested at the Supreme Court. So we're going to kind of take this in order so it makes the most sense. So let's talk about Mifepristone. Mifepristone, like I said, is the most commonly used abortion medication here in the United States. It was approved by the FDA in 2000, and it was approved for use in a 2-step abortion process through 7 weeks gestation. So that 2-step abortion process is Mifepristone, and then the second drug is misoprostol. So at this time, when the FDA approved it in 2000, the FDA also put restrictions on its distribution. So one of the things that they required was in-person dispensing. Another thing that was required was provider attestation and certain reporting requirements. And it also required a patient agreement form. So the patient had to sign off on it. Well, 16 years later, in 2016, the FDA approved a separate new drug application, which is called an NDA, not like non-disclosure agreement, but new drug application for Mifepristone through 10 weeks gestation. So they extended it from 7 weeks to 10 weeks. Then in 2020, a federal district court temporarily prevented the FDA from enforcing the in-person dispensing requirement because of the pandemic. So obviously people weren't going to the doctor. They couldn't get the medication. So a federal district court said, hey, look, you don't need to go in person to get this drug anymore. It can be mailed now. Well, the next year, the FDA said that it was going to exercise enforcement discretion with respect to the in-person dispensing requirement. So now the FDA was saying it's up to them to decide when to require in-person dispensing and when mailing is okay. And then just this year in January, the FDA approved modified REMS, which stands for Risk Evaluation and Mitigation Strategies. And these modified REMS removed the in-person dispensing requirement. So now you no longer had to go to the office to get this medication. You can get it through the mail. And it created a pharmacy certification requirement. So in a sense, it did make it a little bit harder to obtain these drugs by way of that pharmacy certification requirement. So this is where the Washington case comes into play. In Washington, 17 states plus Washington, D.C., sued the FDA seeking to expand the availability of Mifepristone. And it stemmed from these new modified REMS that were implemented in January. And they said, hey, look, we don't want Mifepristone to be less available. We actually want to expand availability of it. So they sought a preliminary injunction, which we've talked about a preliminary injunction before. It's basically where you stop someone from doing something. And we'll get into the requirements in a minute, but basically what they said was, hey, we want a preliminary injunction to stop the FDA from enforcing these new REMS and making Mifepristone less available. So the court granted that injunction. And what the Washington court said is that, okay, we can't grant this injunction as far as the whole nation. Like we can't say the FDA is prohibited from implementing these new REMS across the country. But what we can do is say they're prohibited from implementing these REMS to you guys, the 17 states plus Washington, D.C. So that was the order there. So it said in those 17 states plus Washington, D.C., the FDA couldn't make the Mifepristone any less available. They had to maintain the status quo. So those are kind of the key words, maintaining the status quo. They couldn't change anything. Well, then you have the Texas case. And this was various doctors and doctors' associations that brought this lawsuit against the FDA, challenging the approval process of Mifepristone. And they argued that since day one, since 2000, the FDA's approval was flawed because it didn't adequately review safety risks. And they asked for a preliminary injunction, which would have not only withdrawn the FDA's approval of the drug, but it would have also disallowed the mailing of Mifepristone. So I said we were going to go over the elements of a preliminary injunction. Let's do that now. And then you'll be able to kind of understand why it was granted in this case according to this judge. Keep in mind, every judge would have ruled their own way on this. It's not to say one judge is right and one judge is wrong, but this is what this judge found. So in order to grant a preliminary injunction, these are the 4 things that need to be present. 1, there has to be a substantial likelihood of success on the merits. And this doesn't necessarily need to mean that the plaintiff is going to win the case. They just need to demonstrate a reasonable probability of success. Just that their case has merit, if you will. Like, it's not a sham case. So the second thing is that there has to be a substantial threat of irreparable harm if the injunction isn't granted. The third thing is that the threatened injury has to outweigh any harm that would result with an injunction. And the fourth element is that the grant of injunction is in the public interest. Now, when the government is an opposing party, as it is in this case, per Supreme Court precedent, the last 2 elements are actually combined into one. So the threatened injury outweighing any harm that would result with an injunction, and the granting of the injunction has to be in the public interest. Those 2 things are merged into one. All of these elements, the judge answered in the affirmative. So he said, yes, there is substantial likelihood of success on the merits. Yes, there is substantial threat of irreparable harm if the injunction isn't granted. Yes, the threatened injury outweighs any harm that would result from an injunction. And yes, the grant of the injunction is in the public interest. Therefore, the preliminary injunction was granted. If you answer all 4 of those in the affirmative, you got to grant the injunction. But what he said is, he said, quote, although the court finds that the plaintiffs have a substantial likelihood of prevailing on the merits, the court exercises its authority under the APA to order less drastic relief. And what he meant by this is he postponed his order for 7 days to allow the government to seek emergency relief from an appellate court. So what he could have done is said, yes, I'm granting the injunction as of now. Immediately, the FDA has to withdraw its approval. But what he said is he's going to stay the order for 7 days, meaning the government has 7 days to appeal this, and they did. So that takes us into the appellate decision. So the Texas decision was on Friday. The government appealed it on Monday, and by Wednesday night, the appellate court had granted the DOJ's request to put the Texas order on hold, but carved out some restrictions. So what they said in the simplest of terms, I'm going to make this super, super easy to digest. What they said is that Mifepristone can still be provided to patients, but it has to be given in person, so you can no longer mail it, and it can only be given up to 7 weeks of pregnancy, not 10. From there, the Biden administration took it to the Supreme Court. So on Thursday, they asked the Supreme Court for emergency relief to block the Texas order in its entirety. So they want the whole order blocked. They don't want any restrictions in place like the appellate court put into place. They just want the order blocked as a whole. Now, we don't have an update on that because this just happened yesterday. If you're listening to this on Friday, I'm sure we'll have an update soon, though. I have a feeling this issue is going to move fairly quickly, but as of now, we don't know what the Supreme Court is going to do. So where do we stand currently? Let's talk about that. In the 17 states where the Washington judge said that the status cannot change, the status will remain the same. In the other states, Mifepristone can still be dispersed, but it can only be dispersed up until 7 weeks gestation, and it has to be given in person. The appellate court's decision to put Texas's order on hold partially and implement those restrictions doesn't change the Washington ruling. So a little bit of conflict happening here, which is why it's now up to the Supreme Court to resolve the dispute and figure out what to do. They're the law of the land. They're going to ultimately decide how this is going to go. In the situation that the Supreme Court says Mifepristone is no longer FDA approved, that they have to withdraw their approval, what would likely happen is that abortion providers would switch to misoprostol abortions only. So remember how I said it was a 2-step regimen? they would only use that second drug. The reason that they don't only use the second drug now is because the second drug is slightly less effective and it has slightly more side effects. But worst case scenario, if they still need to provide a medication, that's what they would do. So that's the deal with the Mifepristone rulings. I'm sure we'll have an update from the Supreme Court soon, like I said, but for now, that's where it currently stands. So I hope that cleared things up for you guys that were a little bit confused. Whenever courts issue conflicting rulings like this, it can really throw people off and no one knows where it stands. And also too, whenever you have the appellate court involved, like it is here, it's hard for a lot of people to know where, does that appellate ruling affect me, or does it only affect certain regions, certain states? Like, how does that work? So I hope I cleared it up for you guys. And with that, let's get into the third story. Justin Jones and Justin Pearson were both reinstated to the Tennessee House this week. Last week, I had spoken about this in a story, and I only covered Justin Jones because Justin Pearson was expelled later that night within, I would say, an hour of me recording. That's just the way of the news. What are you going to do? Whereas Gloria Johnson was able to remain in the House. So there were 3 representatives who were facing expulsion. 2 of them, Justin Jones and Justin Pearson, were expelled. Gloria Johnson was not. If you need a recap on that story, go ahead and listen to last Friday's episode. You'll find that at minute 17:55. So whenever members of the state legislature in Tennessee are expelled, it doesn't happen often, but when it does, Section 15 of the Tennessee Constitution applies. And what it says is that when there's more than a year until the general election, the legislative bodies in the counties that have vacancies will elect an interim representative until a special election can be held. So they're not going to wait until a general election. They're going to hold a special election, but until that special election takes place, they elect an interim rep. Now, if this were less than a year until the general election, the only thing that would change is that the interim rep would only serve until the general election took place. So knowing that, in Justin Jones's case, the Nashville Metropolitan Council was the one who voted on an interim rep, and they voted unanimously to appoint him as the interim rep. He then returned to the House on Monday, and he took the mic to say, in part, "I want to welcome the people back to the people's house. I want to welcome democracy back to the people's house. On last Thursday, members tried to crucify democracy, but today we have a resurrection." So from here, he'll serve as interim rep, and a special election will be held. He can run in that election. I would imagine he'll get reelected, and then he can also run in the general election. So he may never see a day out of the House again, and it may have only been those few days. And then in Justin Pearson's case, the Shelby County Board of Commissioners were the ones who voted on his appointment. They voted 7-0. There were 13 members of the Board of Commissioners, but only 7 were present to vote, but they all voted in favor of his return. So he returned to the House on Thursday. And again, same thing with him. He can serve as interim rep for now. Once the special election happens, he can run in that, and then he can also run in the general election when that takes place. And now that they've been reinstated, they're able to file 15 new bills. So there was a Tennessee law that was enacted in 2013 that said each House member has a 15 bill limit. So it imposed a limit on the legislature because before, people were just filing bills left and right. So prior to the limit, Tennessee was actually averaging just over 4,600 bills per session, which is almost 35 bills per member. So they capped it at 15 bills. So now that they're considered new members, they're able to file 15 new bills as if they just started their term. And what happens to the original 15 bills is that when they were expelled, they were actually transferred to the representative who leads the Democratic caucus. So now they get 15 new bills, and Justin Jones specifically said that each of his bills are going to have to do with common sense gun laws. So that's what he plans to do. Now, part 2 of this story is a story that kind of flew under the radar. It didn't really make headlines, which is interesting because when Justin Jones and Justin Pearson were expelled, it was the top story. But on Wednesday, the Arizona House voted to expel Republican Representative Liz Harris. And she was expelled for ethics violations after she invited a conspiracy theorist to publicly testify before lawmakers in February. So in February, Harris held a joint hearing for what she says was meant to ensure that the voters of Arizona were confident in all future elections. But what she did was she invited this girl named Jacqueline Breger to present findings of an investigation in which Breger claimed that various elected officials and judges had taken bribes from a drug cartel and were involved in money laundering, drug trafficking, drug sales, public corruption, election fraud, like all of these different things. And one of the members eventually stood up and asked her how she was invited to speak at the hearing. Like, why was she here? And she said that Harris had invited her. And there's a video of this where Harris is seen making a gesture, moving her hand across her neck, almost like cut it out or like don't throw me under the bus. And you can see her mouthing something to Breger. But from there, a complaint was filed against Harris and an evidentiary hearing was held. And ultimately, the committee said in their findings, they said, quote, Representative Harris knew or was at least aware that Breger would present criminal allegations at the joint hearing, and that, quote, as the primary organizer of the joint hearing and acting vice chair during Breger's presentation, Representative Harris violated the inherent obligation to protect the integrity of the House. The vote to expel her was 46-13. Even people on her side of the aisle wanted her out. It met the 2/3 threshold, and now, per Arizona law, because the next general election is more than 6 months out, the governor will call a special primary election and then a special general election in order to fill this vacancy. But the special primary has to have its date established within 72 hours of the office officially being declared vacant. And it can't be held within the first 120 days of vacancy, but it has to happen within 130 days of the vacancy. So it gives like a 10-day time slot that this election has to happen. I don't see her having the same fortune that Justin Pearson and Justin Jones had in being, reelected or reappointed, I should say. But yeah, she was expelled on Wednesday, and I feel like it kind of flew under the radar. So I wanted to fill you guys in on that. But that takes us into our last story, which is the suspect that's been arrested in connection with the Pentagon document leak. So I briefly reported on this on Instagram and TikTok, but there's been many updates since then. It was originally thought to be a Russian spy or someone affiliated with Russia that leaked these documents. And then it was originally thought to be just documents related to the war in Ukraine, but it turns out that the source has been leaking documents and pictures for months, and the number of documents is thought to be over 300. So it's definitely a much bigger leak than it was originally thought. And it's an American guy. He's a young kid. He's 21 years old. His name is Jack Teixeira. He's an Air National Guardsman based in Massachusetts. And his unit specifically handles intelligence information that's obtained by surveillance aircraft. So his unit has access to this intelligence information, but it's still not clear how someone at such a low-level position got access to all of these documents. I mean, we're not just talking like a few. We're talking hundreds of documents. So I'll talk about that a little bit at the end of the story, but this leak is actually said to be one of the most serious security breaches in the last decade. So let's talk a little bit about the suspect. Let's talk a little bit about the timeline, and then we'll finish talking about the apprehension of the suspect. Jack Teixeira was a member of a platform called Discord. It's a gaming platform, and specifically, he was the leader of this particular group called Thug Shaker Central. And apparently, U.S. counterintelligence officials have had their eye out for gaming platforms for years because they do tend to be a magnet for spies. So I thought that was interesting. But one of the members of this Thug Shaker Central group says that Jack was known as OG. So they did know his real name, but they didn't refer to him as Jack. They referred to him as OG. And two of the members gave anonymous interviews talking about OG and about the documents that were leaked. And one of the members described OG as a charismatic young man who loved God, shooting guns, and racing cars. And this member said that OG had a bossy attitude at times, but it was more of a fatherly bossy. He was the leader of the group, and he wanted other members to be super soldiers in a way, meaning he wanted them to be informed, fit, with God, and well armed. This member who kept himself anonymous said that he still cares for OG like he's a family member, so he wants to keep OG's identity a secret. Obviously, it's not a secret anymore, but at the time that this interview was done, it was. And the member also said he's not a Russian operative, he's not a Ukrainian operative, and he would even go as far as to say that OG is not even on the east side of the world, which we now know OG's location was in Massachusetts. But he also said that OG wasn't necessarily anti-government, but did disagree with some of their actions in the past, like Waco and Ruby Ridge. And OG thought that the government was overreaching in many aspects. So OG had a tendency to kind of show these people in this group, which is said to be 20 to 30 people in this particular group, the Thug Shaker Central group. But he was leaking all this information because he said the government was oftentimes overreaching and he wanted to let his friends know what the government was up to. And according to the source, OG first began sharing annotated typed excerpts of classified documents. So he would summarize these classified documents and post them. And then later, it became pictures when he wasn't getting the attention that he wanted from the documents. So the documents or the typed excerpts weren't interesting enough, and then it eventually led into actual pictures of documents and top secret photographs. So then that member that I just talked about that gave the anonymous interview had his story corroborated by a second member who also spoke out anonymously, but said pretty much the same thing, described OG the same way, said that, he knows OG's real name, he knows where he lives and where he works, but he's not going to share that information with anyone because he cares about OG. And he said that OG would tell the group things about the government that the government was hiding from the public. So as an example, this member said that one time OG told this group that the government actually knew in advance that a white supremacist was going to go on a shooting rampage at a Buffalo supermarket in May 2022, but that the government let it go forward so that they could argue for increased funding. So that's one of the stories that OG told this group. I don't know how much truth there is to that, but that's kind of the gist of what OG was sharing. And then at some point late last year, he started, sharing these documents and excerpts, but it didn't come to the attention of U.S. authorities until just over a week ago. And this is kind of what that timeline looks like. So on March 4th, 10 documents were posted to a Discord server, and the server was titled Minecraft Earth Map, and it became available to thousands of Discord users. It didn't reach the US though for another month. So sometime in the middle of March, OG actually stopped sharing pictures, probably because these pictures were leaked in this Minecraft Earth map and available to thousands of people when he just intended for them to be available to the 20 or 30 people that were in his group. So he stopped sharing pictures. But then on April 5th, a month after these 10 documents were posted to this other server, more classified documents that depicted the war in Ukraine were posted on Russian Telegram channels, which eventually migrated to Twitter. And the next day is when the New York Times first reported it. And that's the day, April 6th, that allegedly OG came back to the server very frantic, said something had happened, it's in God's hands now. And it got to the point where members of the group were actually sobbing and crying because they realized OG was in trouble and he was disappearing. So his final message to the group was to keep low and delete any information that could possibly relate to him. So that was his last communication in the group. Then on Thursday, so yesterday, late morning from Ireland, President Biden told reporters that investigators were closing in on the source. And what he said was that there's a full-blown investigation going on. The intelligence community and the Justice Department, they're getting close, but there's still not an answer. And he said he's not concerned about the leak. He's concerned that it happened, but there's nothing contemporaneous that he was aware of. So that was Thursday morning. Then, as of Thursday afternoon, around 2 p.m. Eastern time, the suspect had been taken into custody. So law enforcement went and surrounded this home belonging presumably to his mom. The owner of the home is listed as Dawn Teixeira, which his name is Jack Teixeira. I'm just guessing it's his mom. Maybe it's not. I don't know. But it's a home in Massachusetts, and they surrounded it. And this kid just walked out of the house without incident. He walked backwards towards the agents with his hands up until he got to them where he was handcuffed, and they They sat him down in the back of the military truck, and then they ended up walking him over to another car. There's video footage of it, but he didn't, I mean, honestly, I was expecting this to be a little bit more dramatic, but he surrendered very easily. And that was that. So there's still obviously questions that remain, like how did such a low-ranking officer have access to such highly classified material? There were reports that in some instances there's these brief writers that basically brief the higher ups on certain documents. So maybe that's how someone in a lower ranking position got access to these documents, but it's still not clear. And there's also questions as to who handles this prosecution. Should he be criminally charged? I'm assuming criminal charges are going to be brought, but is it the DOJ? Is it, the Department of Defense and the military? Like who is in charge of this? They do have a protocol where their jurisdictions kind of overlap. So I'm sure they know the answer to it. It's just not, the answer's not super clear to the public. And when the Pentagon was asked in the press conference, they didn't answer that question. But when something similar happened with Snowden, the DOJ was the one that brought charges. And it was 2 counts of violating the Espionage Act of 1917. This is obviously before he was ultimately granted citizenship in Russia and swore his oath of allegiance there. But I would imagine it's going to be a similar situation here. Now, the Espionage Act of 1917 prohibits obtaining information, recording pictures, or copying descriptions of any information relating to national defense with the intent or reason to believe that the information may be used for the injury of the United States or to the advantage of any foreign nation. So it sounds like it applies to this situation, but again, it's gonna come down to what his intent was, if he thought that, this information would harm the United States. I think Snowden had much more obvious intent than this kid, but we don't know. It's all going to come down to what comes to light in the coming days and the coming weeks. And there's still a lot of answers to be solved here. We don't really know anything except who's responsible for it. So that was the last story of the day. I hope you guys enjoyed this episode. Please don't forget to leave me a review on whichever platform you listen. It really, really, really helps support my show. And with that, I will talk to you next week.